In the next few lectures, we're going to examine the judicial branch, with a particular eye towards judicial review. In the common phrase, judicial review is when a court strikes down a law that it determines to be unconstitutional. This lecture is mostly going to lay the foundation for how the court system works. Two preliminaries. First, you should know that judicial review is nowhere mentioned in the Constitution. You can make an argument that it is implied or even logically required, but it is not a written duty of the courts. Second, know that judicial review is not universal. The United States has a relatively strong version of judicial review, from the global perspective. On the other hand, some democracies have no judicial review at all. One example is the United Kingdom. The UK Supreme Court cannot strike down acts of Parliament. At most, it can advise that, in its view, an act of Parliament conflicts with the UK's treaty obligations. But, in the end, this is just a recommendation. Parliament may or may not act on the Supreme Court's advice. We need to distinguish judicial review from statutory interpretation. Many, in fact most, court cases, even at the Supreme Court level, do not involve the Constitution at all. The majority of the Supreme Court's work involves statutory interpretation. This is the act of clarifying the meaning of an ambiguous statute. Remember, a statute is an ordinary law passed by a legislature, blue in our color scheme. Let's try an example. I could pick from thousands, but this one is easy to explain and commonly known to first-year law students. A criminal statute reads, "Any person who, during and in relation to any crime of violence or drug trafficking crime, uses a firearm, shall be sentenced to an additional 5 years in prison." This is what we call a sentencing enhancement. The 5 years for the gun go above and beyond the punishment for the underlying crime. So, 5 more years if you use a firearm while committing a drug crime. Here's a question. What if the way you used the gun was to trade it for drugs? Does the statute include that behavior? Or does using the gun require pointing it, or brandishing it, or firing it? Seriously, how would you rule? This is the core of what appellate judges do. They interpret words. It's like English class. What is the best reading of use in this sentence? This kind of work is the bread and butter of the Supreme Court, but you rarely hear about it. Most statutory interpretation cases get minimal press compared with the flashier constitutional cases. In this case, the Supreme Court did rule, 6-3, that to trade the gun was to use it. This prompted a spirited dissent from Justice Scalia, who wrote, "When someone asks if you use a cane, he's not asking whether you have your grandfather's antique cane on display on your wall. He wants to know if you walk with a cane." How is judicial review different? In judicial review, a court interprets 2 laws, not 1. The court determines the meaning of an ordinary law and the meaning of the constitutional higher law to see whether they conflict. If they do, the ordinary statute must be struck down. Contrary to what many Americans think, striking down laws is not the core use or purpose of judicial power. The true meaning of judicial power is the power to decide cases and controversies between specific parties by applying the law to facts. In fact, judicial review is more like a byproduct or an accidental consequence of deciding cases. In Marbury v. Madison, Chief Justice Marshall explained it like this: "Those who apply the rule to particular cases must, of necessity, expound and interpret that rule. Thus, it is emphatically the province and duty of the judicial department to say what the law is." Before we go on, it may be helpful to show the structure of the state and federal court systems. Nearly every state has a similar structure to the federal government, which is trial courts at the bottom, where cases begin. The losing party may file an appeal and have an intermediate appellate court review the case, potentially correcting legal errors. Finally, there is a court of last resort, usually called the Supreme Court, whose rulings are binding on every court below it. There is one extra step at the state level. If you lose in a state Supreme Court, you can still petition your case to be heard in the U.S. Supreme Court, if a question of federal law is concerned. For example, take a criminal defendant in the state justice system who argues that he did not get a fair trial under the Due Process Clause. Since this is a claim concerning a federal law, the 14th Amendment, he may petition to the Supreme Court to hear his case, but only after exhausting all options at the state level. We'll now look at each level of courts in greater detail. First, the trial courts are where fact-finding occurs. Normally, juries make findings of facts. For example, did Smith, in fact, trade a gun for drugs? The role of the trial judges is to instruct the jury on what law to apply, to make decisions about what evidence can be introduced and the arguments the lawyers can make, and to oversee an orderly trial. There are around 600 trial judges at the national level and thousands in the state courts. Trial judges can and do interpret the laws and can strike down a law like any other judge. However, legal issues of national importance almost never end at the trial court level. The next step is the courts of appeal, or appellate courts. Appellate is the adjective of appeal. These courts serve as a system of error correction, giving cases a second look in case something went wrong below. They also clarify and interpret the meaning of laws, creating uniform interpretations to be applied in the trial courts below them. At the federal level, there are 13 circuit courts of appeal. Michigan is within the 6th Circuit. If you have a case in the federal courts and you lose in the district court in Detroit, your next step would be to appeal to the 6th Circuit Court in Cincinnati, Ohio. All but the smallest states also have intermediate appellate courts like these. The Supreme Court is a court of last resort. Unlike the lower courts, it can choose its own caseload. Thousands of people who lost in the courts of appeal, or in a state Supreme Court, petition the justices to hear their case. To use the official term, someone who wants a case to be heard files a petition for a writ of certiorari, or a cert petition for short. In a typical year, the Supreme Court might receive 7,000 or 8,000 petitions and grant cert in only 50 to 80 cases. For the 99% of people whose petitions are denied, the judgment of the lower court becomes final. A note on terminology: people who serve on Supreme Courts, state or federal, are called justices. People who serve on any other lower court are called judges. How does SCOTUS, that's Supreme Court of the U.S., choose which cases to take? Most commonly, it hears cases to decide legal issues when there has been a circuit split, when at least 2 circuit courts have interpreted a law and come to opposite conclusions. In addition, some issues are of such national importance that the Supreme Court may choose to take a case even without a circuit split. For example, if a lower court strikes down an act of Congress, SCOTUS will normally decide to hear the case. The Supreme Court has an internal rule that it will hear a case if at least 4 out of the 9 justices agree to grant cert. Article 3 of the Constitution concerns the judicial branch. Article 3, Section 1 begins, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may ordain and establish." Note that while a Supreme Court is mandated, Congress may organize the lower courts however it pleases through legislation. Furthermore, the size of the courts, including the Supreme Court, is not fixed. SCOTUS began with 6 justices under President Washington, and it grew to 10 justices by the Civil War, but it has stayed at 9 ever since Reconstruction. Article 3, Section 1 continues, "The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and their compensation shall not be diminished during their continuance in office." So, this provides that federal judges serve for life terms. Good behavior means that judges cannot be removed from courts unless they are impeached and convicted. As we'll see later, only one Supreme Court justice has ever been impeached, and even he was not convicted. The system is very different in state courts. Most states have fixed terms of office for judges and justices. Of course, the specifics vary under each state constitution. Justices on the Michigan Supreme Court, for example, are elected by the people. They serve for 8 years at a time, and they may run for re-election until they turn 70. Yes, Michigan places an age limit on state judges. Finally, Article 3, Section 2 defines judicial power. The courts may only decide cases and controversies, which limits their power. Courts cannot randomly weigh in on any issue. There must be a specific lawsuit or criminal case for them to rule on. Next, we get to the distinction between original and appellate jurisdiction. The Supreme Court almost never hears cases in the first instance. Nearly every case must begin in a trial court and work its way up to SCOTUS. But there is an exception. In a tiny number of situations, a case can begin directly in the Supreme Court, and this is called original jurisdiction. Article 3, Section 2 spells out what these cases are. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. It's been decades, if not longer, since the Supreme Court has had an original jurisdiction case concerning ambassadors or other diplomats. Cases in which a state shall be a party, in practice means lawsuits between two states. Usually this happens when states have a border dispute, or a disagreement about water rights when a river flows between them. The Supreme Court might get a case like this every 2 years or so. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction. This is virtually all of the Supreme Court's docket. Over 99% of their cases begin in a lower court and reach SCOTUS through a cert petition.